Discrimination at work can be subtle or overt, but no matter the form, it's damaging, disheartening, and illegal. If you've ever felt like you were treated differently because of who you are, you may have more rights and options than you think. Today, let's walk through how to recognize workplace discrimination, how to respond appropriately, and how to take legal steps to protect yourself and your future. What counts as workplace discrimination? Under federal and California law, discrimination happens when an employer treats an employee unfairly or less favorably based on a protected characteristic. These include race or ethnicity, gender or sexual orientation, age, 40 and older, religion, disability or medical condition, national origin, pregnancy or parental status. Discrimination can happen during hiring, promotions, job assignments, compensation, or termination. It can also show up in the form of constant microaggressions, exclusion, or denial of opportunities given freely to others. If decisions about your work are being influenced by bias rather than your performance, that's a problem and potentially a violation of the law. Step 1, document the discrimination. Start writing everything down. Keep a personal, dated record of discriminatory remarks, treatment or behavior, emails or messages that show bias, job changes, demotions, or denied opportunities, names of witnesses who may have seen or heard what happened. Even if something feels small in the moment, it could later help establish a pattern. Step 2, review company policies. Most employers have anti-discrimination policies and internal complaint procedures in place. Review your employee handbook or HR portal to understand how and where to file a formal complaint. Use these procedures if possible, but remember, even if your workplace doesn't follow its own rules, your rights under the law still stand. Step 3, file a complaint internally. Report the behavior in writing to your manager, HR department, or designated compliance officer. Be clear, concise, and factual. Avoid emotional language and focus on what happened, when and where it happened, why you believe it was discriminatory. This report becomes a key part of your record and shows that you attempted to resolve the issue through proper channels. Step 4, know the deadlines. If the situation doesn't improve, or if your employer retaliates, you can file a legal complaint with the Equal Employment Opportunity Commission, EEOC, or the California Civil Rights Department, CRD. But time matters. In California, you typically have 3 years from the last incident to file with the CRD. For the EEOC, the federal limit is usually 300 days. Don't wait. Delaying action can limit your legal options. Step 5, speak with an employment attorney. An experienced employment attorney can assess the strength of your case, help you navigate the legal process, and ensure your rights are protected. You may be entitled to compensation for lost wages, emotional distress, legal fees, and in some cases, punitive damages. Your attorney can also negotiate a settlement or help you pursue a lawsuit if needed. Discrimination is not something you have to tolerate. You have the right to work in a space that values fairness, respect, and equal opportunity. If you're experiencing discrimination or retaliation after speaking up, don't go through it alone. Visit employeelawgroup.com for guidance and legal support. We're here to help you understand your rights and take the steps needed to protect your future.